All right, well, hello all, welcome. Thank you for joining us here today on December 6, 2023. I'm here with Wendy Legman from the Tourette's Association of America. My name is Dan Stewart. I'm a managing attorney from the National Disability Rights Network, and I'm pleased to welcome you here for this employment law introduction for Tourette's Association of America and the protection and advocacy system. Today we'll go through some employment law basics. I'll also have an opportunity to highlight some cases that involve situations involving Tourette's. And before we begin, I'd like to introduce Wendy Legman, and she'll say a few words, and then we'll get going into the employment law introduction. So go ahead, Wendy.
Thank you, Dan. My name is Wendy Wegman, and I lead programs here for youth, young adult, and school education at the Tourette Association, and I'm happy to be here.
All right. So first of all, I think, Wendy, I'll just say a couple of words and then turn it over to you for these first couple of slides, Wendy. But I wanted to again welcome people, but also to say that for today's presentation, what we'll do is to respond to questions at the end of the presentation. And so please use the chat. The chat will only be available to the host to view, but you're certainly welcome to post questions in that chat. They will not appear to others except for the hosts. And Wendy and I will leave time at the end to cover as many questions as we can. So I'll turn it over to Wendy for a couple of slides here, and then we'll get going into the employment law introduction.
Great. Thank you, Dan. The first thing I'm going to talk about is what is Tourette syndrome. And it is estimated that about 1.4 million individuals in the United States has Tourette syndrome or another persistent tic disorder. To be diagnosed with Tourette syndrome, one presents with both vocal and motor tics. To be diagnosed with another persistent tic disorder, one presents with either vocal or motor tics. Both are lifelong conditions, and about half of the people in the United States living with Tourette syndrome are undiagnosed. So Tourette syndrome is neurodevelopmental. It affects the brain. The part of the brain that is affected by Tourette syndrome is the basal ganglia, and that's the part of the brain that controls what actions to perform at what moments. Symptoms of Tourette, meaning tics, typically begin between ages 5 and 7. And they typically increase in severity and frequency between 8 and 12 years old. Tourette right now impacts males more than females in 3 to 1. Next slide, please, Tim. Numerous studies have confirmed that there is a genetic impact on Tourette syndrome, and many people with Tourette syndrome can trace family members that, even though they weren't diagnosed, may have had tics in the past. Tourette affects all races, ethnicities, genders, and ages. It is a lifelong condition, and there is not a cure for Tourette syndrome. Tourette syndrome is a medical condition that's recognized by the ADA, the Americans with Disabilities Act, and Tourette syndrome usually presents itself in the form of tics, and tics do wax and wane, and they can change over the lifetime of a person to be very noticeable or to be not so noticeable. Thank you, Dan.
Yeah, thanks much. And we really appreciate this opportunity to work with the Tourette Association of America, in part because we know that the protection and advocacy of the PNAs receive cases involving people with this syndrome. And we have seen those types of cases in schools, in employment situations, in universities, and pretty much everywhere where people exist. And we want to make sure as the Protection and Advocacy Network that we have a really good understanding of what Tourette syndrome is, but also the laws that regulate how people can be protected from adverse actions. And also, please stay tuned, but the Tourette Association and NDRN will be doing a follow-up with more details on Tourette syndrome and to give us an opportunity to learn more about that. It is a very complicated syndrome, and it has lots of comorbidities, and that impacts the different ways that PNAs can serve the clients who have Tourette syndrome. So please stay tuned for that, and we're very happy here at NDRN to work with Tourette Syndrome of America, or Tourette's Association of America, as we go forward. So thanks to you, Wendy.
Wonderful. Thank you, Dan.
All right. All right, well, switch gears a little bit and get into an employment overview. And please know that these topics are very detailed and very extensive, and there's no way that we can get to tons of depth in the time that we have for this presentation, but it's really intended as an overview to get some of the main topics and to provide you with some resources for further examination and research. So the first thing that we wanted to do is to ground this discussion on some very basic parameters. And one of these basic parameters and legal frameworks is that most of America and the federal territories are in an at-will employment situation. And that basically means that if an employee works at will, she can be fired for any reason or no reason at all. And an at-will employee has no recourse, no legal recourse or remedy if she is fired unless an exclusion or limitation applies. And we'll get into some of these exclusions and limitations. We also want to acknowledge that Montana and the US Virgin Islands, which have each enacted wrongful dismissal statutes, in those places, termination must be for a good cause. So employment at will doesn't exist in Montana and the Virgin Islands. Next, there are some exclusions. As I mentioned, that most employees are at will, but there are a few groups of employees that are protected in whole or in part against arbitrary discharge. And these are unionized employees, because unionized employees have contracts, and there are rules and regulations developed through the collective bargaining process for unionized employees, so at will does not apply. Public employees, state government employees, city, localities, municipalities, they also have protections written in that overcome that at-will presumption. Then similarly, there are employees with express or implied contracts. Once you have those express or implied contracts, the at-will provision does not apply. The next type of topic that we want to go through is the limitations to at-will. So if you're in an at-will state or location and you don't have any of the exclusions that we went through, there are still some limitations on at-will. The first one is anti-discrimination laws. Federal and in some cases state federal anti-discrimination statutes and case law prohibit employers from taking adverse employment actions against members of protected groups for discriminatory reasons. And we've listed them here. That could be race, religion, gender or sexual orientation, national origin, disability, which I've highlighted on the slide, age, pregnancy status, and genetics. Or as we can see from case law, that one individual might be members of several of these different groups. And so several different protections based on these protected groups can apply. There are some other limitations, and this next one is retaliation for assertion of rights. So this means that many federal and state anti-discrimination statutes protect against firings and in retaliation for the assertion of rights and participation in enforcement proceedings. And so this might be, for example, if there is some type of action by the EEOC, the Equal Opportunities Employment or Equal Opportunities Commission, or a state human rights agency, if they are engaged in some enforcement activities, an employee may not be fired for participating in those enforcement proceedings. Some other examples are whistleblower statutes. So there are certain laws protecting those who report alleged legal violations or misconduct. There are some federal examples with regard to the whistleblower statutes, the False Claims Act, Clean Water Act, Occupational Safety and Health Act. Also, there's another limitation against performance of a duty. And what we mean by that is that if someone is required to participate in jury duty, military duty, or being a mandated reporter, acting as a mandated reporter, those are limitations for at-will employment. Now, turning towards the actual statutes that apply, the actual laws that apply, the first one is Section 504 of the Rehabilitation Act, and that was passed in 1983. And that's the first federal law prohibiting discrimination based on disability, including in employment, but it's not just employment, but it's protecting those who are employed by entities that receive federal financial assistance. The next one is Title I of the Americans with Disabilities Act, and that was passed originally in 1990, and that expanded protections for discrimination to private entity employer. And there are some exceptions that we'll get into a little bit later. But think about Section 504 as protecting those who are hired by entities that receive federal financial assistance. But Title I, these are really private employers. There are some additional laws that protect people with disabilities, and those include Title VII of the Civil Rights Act of 1964. And those are applicable to violations of Title I of the ADA. So there's just a lot of overlap between those statutes. The ADA Amendments Act of 2008 restored congressional intent on the definition of disability under the ADA to ensure broad coverage. I won't get into too many details about that, but there were a couple of US Supreme Court decisions between 1990 and 2008 that got Congress to reinforce and to create additional protections for people with disabilities in 2008. And those protections were to ensure that broad coverage of the ADA. We want to point out that it's also important to look at states and localities, and these states and localities may have anti-discrimination laws that protect individuals from employment discrimination based on disability. So it's not just the federal laws, but it's the state and municipal localities that may have anti-discrimination laws. Those local laws often overlap the federal non-discrimination statutes, but can provide coverage that are not provided under the ADA or Section 504. And just a couple of examples, there could be a broader scope of coverage in terms of applying to smaller size employers, or having a longer and different statute limitations, a time period in which a person can file, or no or larger limits on damages that a person with a disability can seek. So one way of thinking about this is that the state and local laws can go beyond and provide more protections than the federal law, but those state and local laws cannot provide less protections than the federal laws. Okay, so a little bit more details on the ADA, because that's one of the major ones that the protection and advocacy system sees, as well as overall scope. But the Title I of the ADA covers employers with more than 15 employees, and those 15 or more employees have to work at least 20 calendar weeks in a year. Also applies to state and local governments, employment agencies, labor organizations. Importantly, the ADA does not cover the federal government, but the federal government is covered under Section 501 of the Rehab Act. The ADA also does not cover Native American tribes who are employers. Okay. Here are some more details about the coverage. The ADA, the Americans with Disabilities Act, provides legal protections only to an individual with a disability, and disability is in quotes because that term disability is defined, and we'll get into that. And it also covers, the ADA also covers people with respect to an association claim. As I mentioned, the definition of disability is detailed, and I'll get into that. The Title I of the ADA definition is very similar to the definition of disability in Section 504. And with regard to the association claim, a person without a disability may also assert a claim if discriminated against because of an association with a person who does have a disability. And this might be discrimination against a parent because their child has a disability. So here's the definition of disability, and this is for Title I of the ADA as well as Section 504. The term disability means, with respect to an individual, physical or mental impairment that substantially limits one or more major life activities of such an individual, having a record of such an impairment, or being regarded as having such an impairment. So this term applies to three different categories of people: one who has that physical or mental impairment, has a record of having such an impairment, or being regarded as having such an impairment. And there are details for each of these. I wanted to focus on the phrase major life activities. So in the law, you can have a disability, but you also need a substantial limitation of major life activities. And the law has a list of these, and it's a non-exclusive list. So for that, the definition, major life activities include, but are not limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. And then the other term that's there is major bodily functions. And for the purposes of that definition, a major life activity includes the operation of a major bodily function, including but not limited to functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. So the overall point of this definition is that it's supposed to be pretty broad. You can see with both the major life activities and the major bodily functions, the definition is meant to be broad so as to include as many people as practicable who have these different types of meeting those definitions. I think it's also important to note that the law has a provision for people who are regarded as having such an impairment. And this is important because there's a lot of stigma still against people with disabilities. And while certain people have disabilities that are diagnosed or there's a record of them, there are people without that still are regarded as having such an impairment. So the provision applies for a person who meets the regarded as if that individual establishes that he or she has been subjected to an action prohibited under this act because of an actual or perceived physical or mental impairment, whether or not the impairment limits or is perceived to limit major life activity. I'll also note that one example of regarded as, a very common example is someone who maybe has some type of disfigurement from being burned, for example, in a fire or chemicals or whatever. So they might look different because of those burns or that disfigurement, but they don't have any other type of disability, but it's just that they might be regarded as having a disability, but they actually don't. So that's one example of regarded as. Okay. Importantly, these definitions don't apply for impairments that are transitory and minor. Transitory impairment is an impairment with an actual or expected duration of 6 months or less. Okay. There are more definitions, and I'm just spending some time with these because it's critical to know how these definitions play together. Title I of the ADA protects people who have a disability and are qualified for the job, and we want to focus on the term qualified. that qualified individual with a disability must meet objective job requirements such as education or training. We've listed a few there. For example, a college degree, 5 years of sales experience, ability to speak Spanish, ability to be an ASL interpreter, being an attorney. And that person must also be able to perform the essential functions of the job with or without reasonable accommodations. So the point here is that to be covered under these laws, you have to have that disability. But now the next layer is that you need to be a qualified person, qualified individual with a disability. And then the next layer is that you also have to be able to perform the essential functions of the job with or without reasonable accommodations. So it's not just having that disability, but there are other steps involved. And as we will see, courts will look at each of these definitions very carefully in determining whether or not someone is protected from the disability discrimination. So here are some essential job functions as well as marginal functions. Title I of the ADA assumes that jobs have essential functions and marginal functions. And as in the previous slide, a person must be able to perform the essential functions of the job, but not necessarily all the job functions, such as those that are marginal. The essential job functions are those that include the fundamental job duties of the position. Reasons job functions may be essential include the job exists to perform that function. For example, proofreading is an essential function for a proofreader, or doing ASL interpretation is an essential function for an ASL interpreter. You get the idea. Some additional reasons why a job might be essential are that there could be a limited number of persons that can perform that function. It could be a small administrative staff, so each person must file, take calls, make copies, etc. The function is highly specialized, and the person hired for having that special skill, such as ability to operate a certain assembly line, or maybe an executive chef, or someone at the top of a profession that has that highly specialized skill. And that would be an essential job function. All right, let's go to the next slide. And this next slide, there's a lot of text here. I'll summarize it for you. You can save it for future reference. But the point of this slide is that wanted to show that how these definitions are critical and nuanced. And so while the individual in this first case, the Hearst versus Wendy's of Missouri, has Tourette syndrome, and that Tourette syndrome was manifested by that person making racial slurs through the tics, vulgar and profane sexual, racial, religious statements. That person was a person with a disability, but in this case, the court found that that person was not otherwise qualified to perform the essential positions of the job with or without reasonable accommodations. And the reason was that those outbursts violated the employee handbook requirement. And so that meant that the person was not otherwise qualified, had a disability, yes, but was not otherwise qualified because they were not able to comply with the employee handbook. I'm just the messenger here. I have some substantial disagreements with that, but this is how the court reviews these types of cases. And in another example, in the Ray versus Kroger situation, the Kroger, the employer, moved for what's called a summary judgment, or a way to get rid of the legal case, by saying that the plaintiff, Ray, was not disabled. And they were arguing that the person was not disabled because he was not able to perform the functions of his job. Now, of course, there's going to be back and forth. So while Kroger, the employer, said that this person doesn't have a disability because he's unqualified for the job because of the behaviors, the plaintiff, Ray, argues that he is disabled because he is substantially limited by his Tourette syndrome in major life activities, and he's otherwise qualified. So you can see that these definitions are critically important. And so it's not just someone says that they have a disability or they have a qualifying diagnosis, but there are all these nuances. So there are just a lot of details here. Now, turning back to some more basics, the protections from discrimination under the ADA include actions taken based on disability in any facet of employment, whether or not the discrimination is intentional. The discrimination also includes a failure to provide a reasonable accommodation. So what do we mean by the types of action in any facet of employment? So the discrimination can be based on disability, and that is prohibited. Those types of actions are prohibited in these types of areas of employment: job applications, procedures in hiring, benefits and compensation, advancement, training, discipline and termination, and any other conditions, terms, or privileges of employment. And so one example on the first bullet there, job application procedures, if an employer decides that we're not going to look at anyone at all that has a disability, well, that would be disability discrimination that's prohibited, but it's in the application process. Similarly, if an employer hires a person with a disability and gives them less benefits or less compensation because of their disability, that action would also be prohibited. So kind of the key phrase or the key way of understanding this are that if an employer is taking adverse actions against someone with a disability because of their disability, that is going to very likely violate the ADA. And it's the because of, which is the critical part here. Okay. There's plenty of questions about whether or not someone should voluntarily disclose their disability. Under the law, any applicant or an employee is not required to mention or disclose that they have a disability unless or until they need a reasonable accommodation. And we'll get more into detail about that. If an applicant needs an accommodation during the application phase, then the individual will need to mention the disability. And not just saying a little bit of the obvious, right? Because if an individual with a disability is requesting an accommodation, they will need to say why they need that accommodation, and that why is on the basis of disability. Okay. So there, as I mentioned before, we know that there is considerable stigma against people with disabilities, and so sometimes it feels natural, or you think about not disclosing your disability or advising a client to or not to disclose a disability. But one caution that we wanted to make about disclosure of disability, that there are a number of legal decisions where employers successfully defended against claims by workers with Tourette's, and for that matter, for other disabilities, by saying that the employers did not know the worker had a disability. And here's one example. Again, lots of texts here, but the point is that through the course of the employment with the defendant, the plaintiff never provided documentation about his condition and the effect that it had on his ability to perform. So there's more details of that, but the basic idea is that if the employee with the disability doesn't make their disability known, it's very likely that the defendant, the employer, will say that, well, we didn't know about a disability, so there is no reason for us to provide reasonable accommodations. And even more so, that if the employer didn't know the person had a disability, then it's going to be harder to show that termination or an adverse action was because of disability. So this creates lots of questions and lots of dilemmas for people with disabilities. And I also think that sometimes one way to think about this is that during the job search, you might want to look into that employer and see what their track record is with people with disabilities, what they say on their website, how they seem to engage with people with disabilities. And so you have a little bit of an idea of what the climate is before making that job application, and then to determine whether or not you're going to disclose. Okay. A couple things that we wanted to point out, that during the application process or the pre-job order offer process, there are permissible questions for applicants that employers can raise, and here's one of them. Are you able to do the essential functions of the job with or without reasonable accommodation? So the employer is not asking if a person has a disability or not. Rather, they're asking about the essential functions of the job and whether or not they can be performed with or without reasonable accommodations. And that is a perfectly legal question to ask. People with disabilities can answer yes to this question without indicating with or without an accommodation. So the direct answer can be yes. The person with the disability, the applicant with the disability, does not need to say, yes, I can do the essential functions with the reasonable accommodation, or for that matter, without. It's important to point out that further questioning by the employer may elicit improper information concerning the existence of the disability. So one way to think about this, the employer cannot say, well, do you have a disability? That would be eliciting information regarding the existence of disability. And if the employer were to take the permissible question and to keep on pushing, it seems like, or it may seem like, the employer is looking for information relating to an existence of a disability. All right. So here are some more parameters about what an employer can ask. The employer can state the physical requirements of a job and then ask if the applicant can satisfy those requirements with or without an accommodation. So it might be a manual labor job, a physical labor job, whatever, but then ask with or without reasonable accommodations. Can also ask about the performance of specific job functions. For example, can you do X, Y, and Z? Can you lift 10 pounds to do this? Can you navigate through a work environment that is full of obstacles, things like that? So you can ask about performance. Employers can also ask someone to describe or demonstrate how they would do a job. Similarly, an employer can ask about the ability to meet attendance requirements, a previous job, or the job being discussed. So can ask about the functions of the job and how the person might do it with or without reasonable accommodation, or give examples. But it's when an employer asks about disability or the existence of a disability, that's when employers get into trouble. Switching to post-offer, once an employer makes a job offer, that's what we call a post-offer, the employer cannot withdraw a job offer for medical reasons unless the individual is unable to perform the essential job functions and a reasonable accommodation cannot be provided. We'll get into reasonable accommodations in a few minutes here. The reasons for denying a job must be job-related and consistent with business necessity. So again, it can't be because of disability. We often get asked, as attorneys representing people with disabilities, about confidentiality of medical information. All information about disability and accommodations must be kept confidential. The information can be available to supervisors and medical emergency personnel, and the medical and personnel files should be kept separate for that exact reason. So if you have a need-to-know basis, the employer has a need-to-know basis, can look in the medical file, but not the personnel file, or vice versa. Okay. So one key thing about employment discrimination actions is that there needs to be an adverse action. And so when we're thinking about discipline and termination on the basis of disability, whatever the employer action is, it must be evenly and consistently applied. It must be job-related, it must be consistent with business necessity, and it must be non-discriminatory. And in terms of what an adverse job action is, we're thinking about termination, or moving someone to fewer hours, or to a different, less preferred site that has different types of benefits or parameters. So there needs to be something substantive there to constitute an adverse job action. And if an employer takes those adverse job actions, those are the things that the employer actions must be to be non-discriminatory. And here's a note about adverse action. Again, these words matter. Fox, the plaintiff, this is a Fox versus Costco Wholesale Corporation about 3 or 4 years ago. Fox has not adduced any evidence that he was demoted, received decreased benefits, had worse job duties, or anything else that affected his employment with Costco. Now, going down a little bit, Fox has claimed that he was denied breaks to go home and to take his medicine and go to the pharmacy, even if related to this disability, do not rise to the level of material adverse employment action. Being unable to take a break twice is not the type of demotion, pay cut, or significantly diminished responsibility that are the telltale signs of material adverse employment actions. Again, the overall point is that the employer's action needs to rise to a higher level of adversity rather than a smaller one. So undoubtedly, some bad things happened to the plaintiff Fox here, but it didn't rise to the level of being bad enough. And so adverse action might sound pretty general, but the laws really require that there must be that material adverse employment actions. Also, the note on business necessity, this is a quote from a prior slide, I just wanted to make the point again, is that the business necessity is huge here. And I've put the words here in bold, those outbursts violated employee handbook requirement. And that's just another way of saying business necessity. And so if an employee is not able to meet the terms of an employee handbook, that could violate the employer's rules, and the employer's rules are equivalent to showing the business necessity. And if the person cannot conform to what the court thinks is business necessity, then that person is going to be determined not otherwise qualified to perform the essential functions of the job. So that business necessity is a huge part when thinking about these cases. Switching gears just a bit, there are other types of legal actions that people with disabilities, including people with Tourette syndrome, can bring. There can be a disability harassment type of claim, and that involves disparate treatment or a hostile work environment. Doesn't mean quid pro quo, that is an exchange for favors, for example, so we're not talking about that. But with regard to the hostile work environment, you need to have a qualified individual with a disability. We've seen those phrases and definitions before. The harassment must be based on disability. The harassment must be unwelcome. And that harassment must be sufficiently severe or pervasive to negatively impact a term, condition, or privilege of employment. And importantly, the employer knew or should have known about that harassment and failed to take action. So here's one example of harassment, and a few of these cases keep on occurring because they were good examples. You can review that slide, but what we can learn here is that following down in this text, it says, since the phrase hut, hut, hike is borrowed from football, and Fox alleges that he often touched the floor when he suffered from verbal tics, presumably resembling a three-point stance, we can fairly infer that the phrase hut, hut, hike was mockery of his disability, as opposed to discussing last night's game or motivating each other to get going. And the plaintiffs in this case, Fox, said that's hut, hut, hike behavior by his co-employees lasted for months and months. And so you've got the severity and the pervasiveness in this one example. Okay. So reasonable accommodation, now switching gears to what reasonable accommodations are. Covered entities must make reasonable accommodations to the known physical or mental limitations of a qualified individual employee or applicant, unless it would impose an undue hardship. And these modifications or adjustments to job functions, work environments, policies or procedures, or in the way things are customarily done, so that a qualified individual with a disability gets an equal opportunity. And there are some citations there. So here are some hallmarks, just to put it into a little bit more non-legal language. Any change or adjustment to the job or work environment that allows a person to participate in the job application process, to perform essential job functions, and to otherwise enjoy the benefits and privileges of employment. So again, one of the key factors, the hallmarks of reasonable accommodations, are to figure out different ways that an employer can make a person with a disability on the same standing, the same footing, at the same level of people without disabilities. And so here are some additional concepts to reasonable accommodations. The reasonable accommodation provided need not be the best or ideal, it only need to be effective. The accommodations should assist in performing job functions. And I also think another important concept too is that the reasonable accommodation does not have to be the one that's requested by the person with the disability. Again, it has to be effective. So here are some examples. Reasonable accommodations may include job restructuring, part-time or modified work schedules, including leave of absences, reassignments to vacant positions, acquisition or modification of equipment or devices. These can include assistive technology, appropriate adjustment or modifications of examinations, training materials, or policies. Some of those policies might include disciplinary policies or other types of policies that apply more broadly to people without disabilities and people with disabilities. Provision of qualified readers or interpreters, or other similar accommodations. On the flip side, here's what are not reasonable accommodations: lowering legitimate quality and quantity requirements. One example is that if I'm hired as an attorney, a reasonable accommodation would not to be to get rid of the attorney requirement. That would be a legitimate quality and quantity requirement. Non-adherence to policies and procedures that are legitimate, non-discriminatory, and fundamental. Primarily personal services or devices, and what that means is mainly in the context of assistive technology, or it could be some other type of personal services. But the idea is that if those services or devices are primarily used for personal use, meaning not use on the job, those are not reasonable accommodations because they're not for the employment situation or to address the essential job functions. The other types of accommodations that are not reasonable include accommodations that would cause an undue hardship or to create a direct threat to the business, such as fundamentally altering a job or the business or tolerating violent or abusive behaviors. Here are some notes on reasonable accommodation. If the employer doesn't know about a disability, the duty to provide a reasonable accommodation doesn't exist. And that was one of the examples that I gave before with regard to the Andrews case. And here's another part about the Fox case that we talked about before. Fox never asked for an accommodation while employed as a greeter or as an assistant cashier. Fox's claim seems to be that Costco had to know that his condition would be worsened by his job as assistant cashier, but Fox had previously served as assistant cashier during his time at Costco. There is no reason for Costco to have known Fox could not later perform that job. What is more, he has failed to introduce other evidence that Costco knew or should have been aware that his condition would have been affected by that job transfer. And that quote is really to show that while the employer may have some duty to see if a person needs a reasonable accommodation, but there are certain restrictions and limitations on that. And the law really places a lot of emphasis on the person with the disability making the disability known in order to satisfy the requirements for a reasonable accommodation claim or discrimination based on disability claim. Okay. So here's a little bit more about reasonable accommodations and the very important interactive process. The employer should initiate an informal interactive process with the individual with a disability in need of accommodation. The law calls this a good faith process, which means that the individual and the employer must come to the table to discuss what might work with good faith, so that they're both open and understanding and willing to have a discussion about what actually might work. This interactive process should identify the precise limitation resulting from the disability and the potential reasonable accommodations that could overcome those limitations. So here are some thoughts on making a reasonable accommodation request through the interactive process. The employee should make the request for reasonable accommodation, but a representative such as a doctor, spouse, friend can make that request on behalf of the employee or individual with the disability. Importantly, there are no magic words are required, but even a comment that I want to keep working here may be enough of a request. And so here are some additional tips. It is a good idea to have the request written, dated, and signed. In email may suffice. It doesn't have that signature, but there are some ways to sign an email. The request should include the nature of the disability, the reason for the request, the requested accommodations, and if necessary, a doctor's note that explains the disability and the accommodations. And sometimes that doctor is a good person to explain the connection to the type of disability and the type of accommodation that's being requested. It's also a good idea, if possible, to ask for a reasonable number of reasonable accommodations. This means that you don't have a 10-page list or something like that, but really to think about ones that are going to be the most important and get to the essential functions of the job. And then ask for a response from the employer by a specific date. And then keep a copy of the letter or that documentation, that email, and then track efforts on the calendar, because sometimes time goes past and you're not exactly sure when requests were made or who did what. And if you are making that request, it's probably a good idea to have a good record of when things were done and to have some kind of written copy of those efforts. Okay. I think it's also important to say what the employer might be able to do in defending against a reasonable accommodation request or a claim. And that is a reasonable accommodation must be provided unless it's an undue hardship to the employer. And typically what that means, and there's a lot of law and definitions around what undue hardship is, but basically if the hardship is, if it's too costly, too extensive, changes the essential functions of the job, or if it's otherwise too burdensome, then that results in an undue hardship, and then by definition, it's not a reasonable accommodation. The next type of defense is a direct threat to the health or safety of an employee or others, and so this might be that if a person with a disability is requesting a reasonable accommodation that impacts or limits the ability of the employer to protect the health and safety, then nope, you can't have a reasonable accommodation that results in a direct threat to others. Fundamental alteration, in some ways, it's similar to an undue hardship, but fundamental alteration is maybe one example that I gave earlier, is that if I'm hired as an attorney, a fundamental alteration for a new applicant for the same position can't be that the reasonable accommodation is to not be an attorney, because that would be a fundamental alteration of that position. So there, of course, are some overlap between undue hardship and fundamental alteration, but those are the basic concepts. Before we get to any questions that people have, we have about 10 minutes left. Wanted to point out that there are some great resources out there for reasonable accommodations, in particular. The Job Accommodation Network, that's JAN, people may have heard about it as JAN. The Equal Employment Opportunity Commission has a lot of great resources out there. State Vocational Rehabilitation Agency, or the Vocational Rehabilitation Blind Agency, Computer Assistance Program of the Department of Defense. There's something called the Disability and Business and Technical Assistance Center. And of course, the Tourette Association of America have great resources. So that's what I have for the overview. Thank you for that, hopefully not too long-winded presentation, but there's a lot of substance there. I'm not sure if, Wendy, you have any thoughts before we look at any questions, and then I can look to see if there's any questions. But if people have questions now, please put them into the chat and we can take a look at them. But otherwise, happy to hear any thoughts from Wendy.
No, I don't have anything to share at the moment. I think the presentation was really thorough and super informative. I actually learned a lot too, Dan. So thank you so much for that. And I'm just here to support with any questions.
Right. So I'm looking at the chat and I don't see any questions right now. People can also raise their virtual hands or put something into the chat and then we can respond. We see a question from Michael. Michael, you are on mute, and you may need to use the chat if we're not having, yeah, thank you, Michael.
Okay.
Oh, wait, there we go.
Oh, there we are. Perfect. Well, yeah, thank you so much, Dan. Really enlightening presentation here. I appreciate you coming in. I have Tourette syndrome. My name is Michael. I'm also a career coach. So I work with a lot of job seekers that are neurodivergent, people with Tourette, ADHD, things like that. And something I've heard from some of my clients in the past is they'll tell me stories about being on a job interview. Maybe they were ticking in the interview and they disclosed their Tourette in the interview. They had what was otherwise a great interview. They thought they did well. They met the essential functions of the job. And then they didn't hear anything back after that, or they got a rejection. And they suspected that the candidate suspected that it had to do with them disclosing, with the disability, that it was going to be because they had vocal tics. The person's reaction may have suggested that they weren't comfortable with it and comfortable with vocal tics in the workplace. We can't prove that. It's so difficult to make that case. So have you learned anything about what advice or tips I could share with my candidates? So if they are disclosing in an interview, how can they set themselves up for success? Also, if it does end up going to some, into the legal realm and they want to challenge this, is there certain information they can try to get? Should they record the interview? What will help them have the strongest case to protect themselves?
Yeah, that's a critical question, Michael, and thank you for raising it. And I think you hit the nail on the head by saying that a lot of these things are just impossible to prove. So most employers have learned how to show a non-disability related reason for their decisions. And you might get the standard, we hired someone with more qualifications, or we're looking for something else. So it's unless there are very specific examples or an email trail or some way to show that the non-hiring or whatever the employer does was on the basis of disability for that individual, or systematically on the basis of disability. There are cases that employers say, we're not hiring anyone with disabilities. Okay, so that would be a bad thing. And if someone finds that through discovery or other legal tools, or by a whistleblower or other ways, that's going to be very hard to do, and very hard to prove that type of case unless you have that evidentiary component. And as we know, that evidentiary component is simply not there. I tend to think about this in a couple of different ways and love to hear other people's responses, but one of them is to do that research beforehand and to really see if an employer is a good fit and meets your values and seems to be welcoming. And that type of employer might have less problems or less hurdles or less discriminatory behavior on the side. And I do realize that that's not the way life should be. I get that. I'm trying to be practical and provide some good advice to set up people for success. So it's that research beforehand, thinking about it, getting some perhaps informational interviews before going through application. A person can explore what it's like to work in that type of environment outside of the employment context, and do some networking with other people to get more information about that. Other things that I've heard include that in the application process, a person may include a note from a doctor or a fact sheet on the disability, or any number of things to kind of prime the employer about what might happen during the interview process. Because sometimes if you're in that interview process and the employer doesn't understand or know, then they might be caught off guard and are maybe have a unconscious reaction to that shows stigma or something like that. So there could be ways to prep the interviewer or the employer about what might happen during the interview, and then at least you're doing some thoughtful work beforehand, and so people know the context and know what might happen. But that also involves the decision to disclose the disability, and sometimes a fact sheet can only say so much, because it's individual symptoms and individual experience with the disability. So, go to the Tourette Association website might not be a good, because it has a very large spectrum of manifestations. But some other things that a person might do are to, talk to colleagues who are there or have been there in the past, or again, really get into that. So that's a bit of an overview, Michael, and hopeful. It's not a perfect answer, I get that, but it's at least some tips. Wendy, do you have anything to add to that?
No, I think you covered it really well. Disclosure is a really big issue in our community in terms of, whether to disclose or not, and especially with employers. And I think at that first and foremost interview in and of itself, so I think that is a decision that can be based on just what you said, Dan. Are your tics going to be apparent during the interview? Are there reasons that you want to disclose before or during the interview so that the people aren't caught off guard? And so I think that's important. And, also, just like you said, Dan, that it's very hard to tell whether somebody isn't hired because of their disability, that's hard to prove. So I just encourage exactly what you said for people in our community to really try to look up different organizations that they might want to work for, research the people that are actually interviewing them ahead of time, so that they might have some background and some comfort level during the interview as well, and do their best. And here at the Tourette Association, anyone can reach out to Tourette.org and go to support@Tourette.org, and we can help give some tips, including even mock interviews that we just did today.
One other idea that just came to my mind is that if a person with a disability, doesn't matter which type of disability it is, if they have a reference from a prior employer that can speak to the job and its qualifications, then that person receiving that already has the reference there for you. Sometimes employers ask for references after that, but there's no harm if you choose to get that reference, and by being thoughtful about what's in that reference letter, working with that former employer, you can think about how the applicant may meet the job qualifications given the disability. So it's kind of putting some more information, some more thoughts beforehand to the employer, so you're doing the best you can. And again, I really acknowledge that this is one of the hardest areas in employment because of the evidentiary problem that you mentioned, Michael, and that you're discussing, Wendy. But we want to make sure that people have opportunities to get jobs. And so there is a practical motivation to thinking about strategies in addition to the legal one. But the legal one, as they've gone through in the presentation, it's fraught with nuances, definitional problems, and complications. So you have to figure out where you're going to put your emphasis.
Thank you. I appreciate it.
All right, we're at the top of the hour. My colleague Milo has put into the chat a link to a SurveyMonkey survey, so we would appreciate you clicking on that and sharing your feedback. Again, happy to have this opportunity with you, Wendy, and thank everyone for their time. Any final words, Wendy, before we finish up?
No, just thank you so much for doing this for your organization and for the Tourette community. We're very excited to have this information. And again, I encourage people to reach out to support@tourette.org and go to tourette.org for resources and support. Thank you, Dan.
Thank you, Wendy, and stay tuned for a further joint webinar collaboration between our organizations. So thank you and have a good rest of the day. Bye now.
Bye, everyone.